I'm Drew Stevenson, and this is a lecture about the case United States versus Locke, a U.S. Supreme Court case from 1985, about whether courts should correct severe results or look for legislative errors and typos in interpreting statutes. Now, this is a case for my statutory interpretation and regulation class, or sometimes called Leg-Reg, and is sort of in the set of cases where we talk about the absurdity doctrine. But here, the majority decides to go with the severe outcome in the case. So let's see what happens. We start with the statute. The Federal Land Policy and Management Act provides that holders of unpatented mining claims will forfeit their claims if they don't file an annual notice with the Bureau of Land Management, or BLM, prior to December 31st. That's what the statute says. You might have expected it to say on or before December 31st or prior to the end of the calendar year, but it says prior to December 31st, which of course taken literally means by midnight December 30th. And that is the crux of this case. And here's our agency, the Bureau of Land Management. And basically, Locke had acquired an interest in this mine. And remember, these are worth millions of dollars. So this is a huge investment. And Locke and Associates filed their first annual notice with the Bureau of Land Management on December 31st. And then the BLM notified them that they had forfeited their claim, that their mining claims had been declared void due to the tardy filing. They were a day late. Now remember, this was the first time they had filed. One might forgive them unless they're using a lawyer who's done this a lot of times and should have known better. Now, the majority here rejected the argument that Congress must have intended a year-end filing deadline and just used awkward wording for it. And they were basically saying, give us a break. It's obvious that statute meant by the end of the year, and we got it in on December 31st. The court reasoned that filing deadlines have an arbitrary quality to them. So, quote, a literal reading of Congress's words is generally the only proper reading. We're going to come back to that idea at the end of the video. The court noted that nothing in the legislative history suggested Congress intended to adopt on or before December 31st instead of the language it actually adopted. Boy, too bad for Mr. Locke that we didn't have some legislative history where they said by the end of the year or something like that, or had used the phrase at committee hearings on or before. It's just we don't really have anything in the legislative history that helps us. What we do have, though, is regulations after enactment from the BLM. And remember, a lot of times we would give some weight to the Bureau, the agency that's entrusted with implementing a statute, and they interpreted it in public promulgated regulations that said there was a December 30th deadline. This also means that parties, if they had looked up the regulation and not just the statute, should have been on notice. Now, the court emphasized that the judiciary is, quote, not licensed to attempt to soften the clear import of Congress's chosen words whenever a court believes those words would lead to a harsh result. In other words, we can't just be results oriented and just do what we want in every case. We have to apply the law and what the law says. On the other hand, note that there is a traditional doctrine called the Scrivener's error rule, which even textualists believe in, by which courts can account for things like typos and other minor errors. These do occur in codes, in the US code and state codes, where sometimes there's a grammatical error or a missing word or a double word or a cross-reference to another statutory section and a number is missing or something like that. And courts are allowed to figure it out and assume that it was a typo by a scrivener. Now, Justice Stevens argued that Congress had obviously meant to adopt a year-end filing deadline, and he explicitly invoked the Scrivener's error rule and said that there was a mistake in the statute didn't really articulate the clear policy. He also says, it points out, and this was actually pretty clever. He goes through the Bureau of Land Management's statute and finds lots of typos and grammatical mistakes and awkward wording and so forth, and compiles a lot of evidence that this was a poorly drafted or hastily drafted statute that wasn't really proofread by anyone. And so, therefore, he says we should assume that something a little weird, like before December 31st, is not deliberate. He also noticed that there's another provision that literally requires claimants to, quote, file in the office of the Bureau, but the practice and BLM regulations allowed filing by mail. So he said, if we have a little bit of leeway or wiggle room to interpret things and not take everything literally, we don't make people file in person at the office, we allow by mail filing, then maybe we could allow things to be in on January 31st too. He emphasized that one would understand how a drafter might inadvertently use the words prior to December 31st when he meant to refer to the end of the calendar year. And so, but he says interpreting the statute literally serves no rational purpose and would be just a trap for the unwary. In other words, if you forfeit your mine interest, that's a devastating loss. And it doesn't seem that Congress would have wanted that. And he couldn't imagine a policy reason for December 30th over December 31st. But I want to ask my students, could you think of maybe a reason, some reasons Congress might have intended before December 31st. Like, for example, we're talking about New Year's Eve. Maybe government offices are understaffed or even closed, or people go home early on New Year's Eve. And so they wanted things the day before. Or maybe there's a flurry of filings at the end of the year that everybody knows they have until the end of the calendar year. So everybody files in the last week or two of December. So maybe they need a day to record them or log them in before the year turns over to sort of keep up or catch up. Now, this case brings out something interesting from a theoretical standpoint about a problem with rules, and the majority alludes to this, and I want to highlight it or draw your attention to it again. Whether we're talking about laws or regulations or institutional rules like the rules at the registrar's office at your law school or the financial aid office or things like that, sometimes we have to have bright line rules for things like filing deadlines, right? We can't just say, please get it in a timely way, because then people will turn it in whenever they want. And if we say, please turn something in by, let's say, March 1st of every year or the 30th of the month, but it's flexible, then people will be coming in 1 day late, 2 days late, a week late, or whatever, and saying that they should get an exception. The same is true for things like eligibility cutoffs, like think about age requirements, that you have to be 18 years or older to do certain things by law, or 21 to do certain things by law. Distance requirements, right, that you have to have a house setback 50 feet from the curb or from the street, or a non-compete agreement that says that's going to say you can't open a business within 50 miles or 100 miles. Speed limits are another one, right? So that's very familiar to people. Now, these same types of bright line rules are often inherently arbitrary. So in other words, if we have something that has to be filed, like registering for classes at your law school, we have to have a date. We have to set some date. And maybe there's no particular reason that one day versus the day before, day after would be perfect or better, but we have to set some date and stick with it. That's the way it works. And the same as needing round numbers for speed limits. Now, I don't think anybody really thinks that, let's say the speed limit is 70 on the highway, that you're really safer going 70 than 71. Or that you're just as safe as if you were going 69. But we really have to pick a number, and it's easier when you're going 70 miles an hour or faster and past a sign to read a round number that ends in 0 or 5 than if we set it at sort of scientifically calibrated at please go 42.7 miles an hour or something like that. So some of these are somewhat arbitrary, like rule 1 higher increment, higher or lower would work also, maybe just as well, but we really have to just make it a bright line rule. So we're going to pick one number. And unfortunately, we then end up really needing to enforce our most arbitrary rules the most strictly, like not have any exceptions. Why? Because if you have an exception, it's not a bright line rule anymore. And so there's something that's paradoxical inherent in rules and regulations that you should recognize, that are arbitrary. We do need arbitrary rules for situations, a lot of situations where we need a bright line or very specific rule as opposed to a host of factors. And then once we do that, we need to usually stick to what the rule says and not start like having a big fudge factor or relax the rule. Otherwise, it's not really a bright line rule anymore. And so the irony or paradox is that we have to be the most strict, and it seems like, about our most arbitrary rules. And so this is a problem. It's a problem with statutes, it's a problem with regulations, and again, it's a problem with institutional and organizational policies. That concludes my lecture about United States versus Locke.